Hey everybody, this is Giancarlo Alino reporting for Sportskeeda MMA, and I'm happy to be joined by my guest today, who's going to give us some information on the class action lawsuit with the UFC. He is very informative in this regard. He is Rob Maysey, founder of the MMAFA. How you doing, Rob?
Good. Thanks for having me.
And Rob, this is something that's been in the news a lot, actually, with the UFC class action lawsuit and just everything going on between that. Can you just give our listeners and viewers here a better idea of how this started, this whole idea of the class action lawsuit?
So, just a little bit about my background. Back in 2002 and 2003, I was living in Los Angeles. I ended up in Eddie Bravo's gym, 10th Planet. Soon after he opened it, one of our teammates, Gerald Strabent, got called to fight on the undercard of UFC 44 against Josh Thompson. So basically the guys in the gym were like, well, let's drive out to Vegas and go watch Gerald. So we did. We drove out as a gym, watched Gerald. After Gerald's fight, he lost towards the end of the first round. About 10 minutes later, he comes into the crowd, and at that time, the lower bowl would be full from the prelims. Right from the first fight, it was full, and the upper bowl would be empty. And I believe it was because at that time the gyms could still afford close to the octagon seats. So it was largely full of gym people that came out to see teammates fight. So after his fight, he comes out to the crowd and he's asking to borrow money to get home. And I'm like, this, it just struck me as crazy. So like right away, I'm looking around. So I'm trying to guess how many people are in attendance. I knew what the average ticket price was. I saw the concession lines. There were like 50 people deep, five, six people across the entire show. So I just started doing calculations. This did not make sense to me at all. So we get back to the gym, and I asked, I was like, why did Gerald have to borrow money to get home? I don't understand this. So like guys in the gym were starting to tell me, behind the scenes, basically how it worked. At that time, fighters were getting paid 2,000 to fight, 2,000 to win. They typically had to fly out an extra corner because they only got one. They had to get a hotel room. They pay gym. They pay agents. They have to pay for their own medicals, brain scans. So yeah, in the actuality, and this was true, well into the 2000s, fighters at the lower levels were actually paying to fight in the UFC. They're not making money at all. They're going out of pocket. Um, so it became sort of obvious to me around 2004, 2005 in particular that the UFC was now making a large amount of money and they were still selling the public as, we're scraping by, we're going broke, we're paying, all that we can afford. They did that, you know, basically up until they purchased Strikeforce. That was their public story, which is just nonsense. It was obvious to me that it was nonsense. So I started writing articles. I did a series on the Ali Act, which applies to boxers. That bill passed into law in 2001. Um, at the time, it only said boxer. It didn't say a combat sports athlete or mixed martial arts. That I believe it was actually May of 2000 that that bill was signed into law. Um, right after that bill passes, Lorenzo Fertitta leaves the Nevada State Athletic Commission. He was a commissioner, and 6 months later, they buy the UFC. And I believe it's my opinion that they knew right from the start we're going to monopolize the sport because that act doesn't cover us. And the mechanism that they use to do it is if the promoter controls rank and title, you have total control over the athlete's career. Now all you have to do is remove other titles, which is what they did. They bought WFA, they bought the assets of affliction. IFL went away. They bought Strikeforce. They bought Pride, and they're not buying these promotions, to continue doing business under them. They're buying them to acquire the fighters and remove the title. After the Strikeforce purchase in 2011, they had virtually every fighter 1 through 15 in every weight class. Joe Silva, and this came out as a result of the antitrust suit, sent an email right before that purchase closed to Lorenzo and Dana. Basically, he cut and pasted fighters ranked 1 through 15 in all the major weight categories, and then in the subject line, he just put "We own MMA." That's it. That's all he said. That's 100% true. Once you accomplish obtaining the top ranked fighters for an upcoming fighter to advance and gain public notoriety, there's only one place for them to go, because they have to beat fighters ranked above them to move up. That's how the UFC has done what they've done. So in 2011, I was a keynote speaker at West Virginia Law School. I gave a presentation as to what has occurred in MMA and the UFC in particular. And at the end of the presentation, one of the professors asked me, why hasn't there been an antitrust suit? And my answer was, because I don't have a plaintiff yet. I can't be the plaintiff. I need a fighter to step up. And sure enough, about 9 months later, that fighter was Carlos Newton. Carlos saw that presentation. He called around, got my number, left me a few voicemails. I finally get him on the phone, and I'm not sure who I'm talking to, because Carlos kind of mumbles at first. He's like, Carlos Newton. I'm like, who? Carlos Newton. He's like, so if I fly into Arizona, you think we can meet up? And I'm like, yeah, sure, I'll meet up with anyone. Who am I talking to? Still not sure. So he finally says it slow enough to where I could hear it. I go, Carlos from Toronto? And he's like, yeah, that's me. And I started laughing, because like literally right to my left in my office, I have a signed poster of Matt Hughes and Carlos Newton hanging on the wall. so I was like, yeah, I'll meet with you, sure. Doesn't say why he wants to meet at all, and I'm kind of thinking, he's not coming in, so whatever. Like literally a week later, he calls, okay, I got my tickets, I want to be there. I think it was the last week in March of 2012. And again, I'm thinking, okay, I'll take him out to dinner or something. He stays a mile from my house. He wants me to pick him up at about 8:30 in the morning, take him into my law office, put him in a conference room with my Westlaw password all week. He did that all week. That's the sole purpose of him coming into town, was he wanted to research case law, and he wanted to convince me, you're doing an antitrust suit. So by like the third day, I take him to a baseball game, and I'm like, Carlos, what are we doing here, man? Because I kind of had an idea. He hadn't said anything. And Carlos laughs. He says, I've seen your presentations. I've seen your papers. I know you figured this out. You're filing an antitrust suit. And I started laughing. I go, Carlos, I'm a real estate lawyer. I don't care. That's what he said. So like literally, yeah, the next day we started working on it. At that time, I had no idea it was going to take us 2.5 years to get filed, which it did. Us flying all around the country, because we had to recruit these national firms to come in and do the suit with us. And also, I had no idea the case would take, we're going on near 10 now since filing. So we ended up filing December 16, 2014. And we just got a trial date. So our trial date is April 9th, 2024.
So this is like, I guess for those that aren't familiar, what's the class action? Like, what does that mean? And like, how did you get to this point where you have a trial date?
Yeah, so a class action, when we filed the suit initially, we filed with 12 guys that was later consolidated down to 6. Those are called the named representative plaintiffs. And those guys were Kung Lee, John Fitch, Nate Quarry, Kyle Kingsbury, Javi Vasquez, and Brandon Vera. Those six file suit on behalf of themselves, but they also tell the court, we want to file on behalf of all the other fighters that fought in a bout in the UFC that were harmed in substantially identical ways to us. You have to get court approval to proceed as a class action, and you have to satisfy a bunch of procedural requirements in order to gain class certification. That happened in August. We finally got the written order from the judge certifying the class. And what that means is no longer is it just those six suing on behalf of themselves. It's those six suing on behalf of a class of 1,215 fighters. So our case just became much more concrete and real. Because we're not, it's not no longer hypothetical. We're suing on behalf of 1,200. We are suing on behalf of 1,200. And the damage amount obviously, grows substantially, six to over 1,000. After the judge certified the class, he called a status conference very soon after. And at the status conference, he said, due to the length of time that this case has been pending, and delays largely out of no due to nobody's fault. There was just delays in part because of COVID, in part because of an appellate appeal. I'm going to fast track the Lee case for trial. I'm going to set it for April of next year. So that was very, very good news for fighters. It was a very good day for the case and for anyone who fought in a bout. It got our case moving again. For 3 years, we were just literally sitting and waiting. Nothing happened for 3 years. And then with that class certification opinion and setting it for trial, we went, instantly to very busy again.
And also, like, you touched on it earlier about Strikeforce and the email that went through. We own MMA. Do you think this class action lawsuit is a reason why the UFC and their owners didn't pursue a deal to try and acquire Bellator when they were up for sale?
I think, this is just my opinion. I think the UFC is probably so their market position is so well cemented now that they really don't have to acquire anyone else. They can just sit and wait for them to go out of business. What's sort of amazing to me and a few of the media people who follow the sport closely is do you follow the Canadian Football League at all?
Yeah.
Okay, so the example that I have started to use to explain this to people is if I went to you and I said, I'm going to invest $1 billion in the Toronto Argonauts, and I'm going to make the Toronto Argonauts the most profitable and famous football team in the world, what would you say? What if I
As
said 2
as
billion,
the owner. Yeah, as the owner, you
10
would have
billion,
to. Yeah.
100 billion? Yeah, the amount does not matter because Toronto plays in the CFL.
Yeah.
Until they play in the NFL, the amount doesn't matter. That is literally what happened in MMA. Until Bellator's fighters can fight 1 through 15, which are all in the UFC, they're irrelevant. So you keep dumping that money. I call it stupid money. You have basically hucksters going out to wealthy investors who don't understand mixed martial arts and stealing money. Dana wasn't lying when he said, I already know the result of this. I know what's going to happen. Well, I do too. Eventually, they are going to go bankrupt and they will go away. It's inevitable until we fix the sport.
And it's also like one of those deals where like PFLs come up and like the market I know in Asia, they have Ryzen, they have One. So is there like this lawsuit against the UFC, will it have an effect on what goes on in Asia and Europe and all these other promotions, or is it just like based on what's going to happen in North America going forward?
So the practical answer is the Sherman Act only applies to basically what happens in the United States. Our relevant market was North America. Now, just by nature of an inertia, what ultimately happens is all of these other promotions, because they're following in the footsteps of the UFC, basically have two choices. We can be have non-restrictive contracts, and our fighters will just use us as a jumping board to get to the UFC. And some of these promotions, the smaller ones here actually advertise that we have UFC out clauses in our contracts, or you get the opposite effect. You get one uh, one in particular who sees the UFC contracts and decides we're going to be even worse than that because we have to lock our guys up even more so than the UFC. Otherwise, we're going to lose any talent that we have that we've put on our shows. That is what happens. That is a typical response to a monopolist's activity. You get basically emulators who, because of their position in the market, have to be even worse than the monopolist. The difference is they don't have any market power, meaning they're so minuscule on the competition map and in terms of revenue that they're generating that they don't have the ability to really dictate to the global pool of fighters what's going to occur. They're getting essentially the pool of fighters that they are getting are the ones that are not getting into the UFC. They're not actually competing head to head. I know they pretend they are, they're not.
And like, I guess even on that, can the UFC have they come out and like, or their lawyers or representatives and said, look, this is a competitive marketplace. The PFL spent all this money for Francis Ngannou. He's coming over. Jake Paul, Amanda Serrano, all these boxing names are coming over. Like, just playing devil's advocate on that. Is this like something that's going on right now to make themselves look like, you know what, we don't really have a monopoly because there's money for these fighters elsewhere?
They haven't gone into the specifics like you did down to the fighter level yet, but that this is the argument they have attempted to make over and over and over. And in fact, they made it again right before our class certification opinion. They at that hearing, their attorney stated over and over what a great competitor Bellator was.
Oh, wow.
Well, let's see how great a competitor they are when they don't exist in 3 months, which is what I believe is going to happen. They're not going to be around. So, what happened to all this robust competition that their their lawyer stood up in court and repeatedly said, "Look at Bellator. This is a great competitor of the UFC." Okay, well, let's see.
Yeah, Dana White didn't have that opinion. When someone asked him if the UFC were interested, he basically said, "Yeah, we're not running a charity. We're not." I don't know why you
He
would
literally laughed.
give that
He's like,
much. Yeah,
why would I buy them? I can just sit and wait. They'll go away."
that's
He's
true.
right. He's 100% right on that.
And also, like the WWE now, they merged with the UFC, formed this big, massive entity, TKO, where over $20 billion is worth. Does this affect the class action in a negative or positive way?
It really doesn't, other than, and we filed a follow-up case. That's the Johnson case. It's essentially largely identical to the first class action that was certified. The difference is the time period. So the Lee case ended as of June 30th, 2017. We filed the Johnson case to go from July 1st, 2017 to the present. In that case, you're going to see essentially a different list of defendants just because of these acquisitions that occurred and ultimately led to the merger with TKO. But in terms of the mechanics of the lawsuit, no, it's largely identical. It's just who's now at the top of the corporate ladder has changed.
And how long do these usually last? These class action trials, like, is it just a one date type of thing, or is this just one of? Are you anticipating like a number of years before it gets resolved?
So both parties at the hearing when our class was certified stipulated to the judge that they believe the trial will last 4 to 5 weeks.
Oh wow.
So that's what the judge is sort of calendaring in his schedule when he set April 9th at the start as the start of our trial. He's contemplating April 9th going 5 weeks out. That's our block of time for the trial. Assuming that trial happens, no, this should be resolved, within the next year or so.
And is this something where commissions are on board as well? Where if some of the actions that take place in this is where contracts aren't restricted, and you need another governing body to administer rankings and all that stuff. Do all the commissions have to sign off and attend this trial as well?
No, the commissions will not have to attend the trial. We have spoken to quite a number of the athletic commissions in regards to another thing that we've been working on is the Ali Expansion Act. And that was, basically the act just takes the Ali Act and expands the definition from boxer to professional combat sports athlete. We had to ask a number of the more prominent commissions if they were on board with that. And almost uniformly, the answer was yes, we already have everything in place because we do the exact same thing for boxing. It's really no burden on us at all. It's no extra cost. It's really no extra work. They have to collect a form, essentially, is what it does. So they were on board with that aspect of it. In terms of the antitrust suit, the UFC is so powerful that it's essentially you have commissions, Utah being the most recent prominent glaring example, that have become captive to the promotion they're supposed to be regulating. It becomes reversed. It's kind of gross, but quite obviously this is happening, and sort of the carrot and the stick that the UFC has used for years and years and years was we want to do X, Y, and Z, and athletic commission, if you don't allow us to do that, we won't hold shows in your state, which means your commission will have no budget. For a lot of these commissions, the 80, 70, 85, 80, 90% of their revenue is coming from 3 to 4 big shows a year, some of which or all of which might be UFC. So that's why you see these states all of a sudden, purse information, prize fighters fight for purses. Every other sport, including boxing, advertises the paydays. It becomes a talking point in and of itself. Well, not with the UFC though. They got the athletic commissions to say these are trade secrets. In state legislatures, these are trade secrets. That's ludicrous. The only reason to have or even to want to keep these secret is you don't want other fighters to know what peers are making because that drives purses higher. That's to me abdication of responsibility on behalf of the athletic commissions. At their core, the athletic commission's purpose is to protect the fighter, not serve the promotion. It's to protect the fighter, and that includes their economic interests. You shouldn't have 4 owners making 85% of the revenue of events. In fact, 4 owners made more than all fighters in the UFC in UFC's history combined. That's crazy. That should have never been allowed. And the reason the UFC has that kind of power and obtained that kind of power is because they were allowed to operate as a reality show while selling their product to the public as sport. And what I mean by that is in any other sport, if I win, I move up. I don't care if you hate my style, if you think I'm boring. If I win, I move up. People thought Floyd Mayweather was boring. Doesn't matter. Nobody could hit him and nobody could beat him. So he could win the title, promote himself, and he made hundreds of millions of dollars. While in the UFC, they're not operating as sport. And as a glaring example of this, Francis Ngannou wins his last fight as heavyweight champion. He still has that title. What did the UFC do? Strips him of the title and gives it to John Jones. Gave it to him. That's not a sport. That's a reality show where the producer is dictating end result. That should have never been allowed. It is a recipe for fighter exploitation because now winning is not enough. I need to please them so they allow me to move up. Should have never been allowed.
And what does this mean for the fighters that didn't compete in the UFC during this stretch? Like, I'm sure there's going to probably be fighters maybe from the early years of the UFC that they were their careers didn't have that longevity and they might feel neglected by this. So, like, what does it mean for those fighters from the early years of the sport?
Nothing directly. Um, we were just a little too late to help some of these guys. Some of the early fighters, they were just a lot. They were just too early to, be frank about it. By statute, these antitrust suits, from the date of filing, we're allowed to look back 4 years. So we filed December 16, 2014. Our class period starts 4 years before December 16, 2010, and goes forward. Now, the practical reality of this is, had we filed in 2005 or six, we probably would have been too early because the UFC hadn't cemented all their moves yet. Now, after Strikeforce, which happened in 2011, now it became apparent. Um, the sweet spot for filing would have been, 2010 to 2014, which is when we did. It's just unfortunately because of that statute of limitations, there are going to be guys that fought on the earlier side that are not going to be directly helped. Our hope is a lot of these guys are still involved in that they teach at gyms or they own gyms or they have kids that want to compete. We want to fix it for those guys too. We want some of these veterans to be able to groom a champion like happens in boxing. So in boxing, a trainer might find a kid who's 14, realize they have the athletic ability and sort of the will to be great. They can take them from they haven't had a fight at all the way to world title. And it will pay them back for their investment in that fighter. Now, with what's happened in MMA, there's no incentive to make any of those investments because you can't monetize it. As soon as that fighter is beyond the regional level, they have to go to the UFC.
And I guess even on that too, like being out of the regional level, like you see other sports, the NBA, NHL, they have minimum salaries for a rookie contract. And once you get through that threshold, then you can make above and beyond up to a maximum of that respective salary cap. So do you think that the UFC is that like a long-term goal where that will be implemented where somebody who's just debuting, like the first thing they can make, let's say off the contender series is like 6 figures as a minimum salary?
I think that's highly, highly unlikely. And honestly, I don't know that that's even desirable. Now, you might have a situation where there are sort of minimum standards established, but combat sports is called the hurt business for a reason, right? It's really in some of the good managers in boxing will actually talk about this. The career arc of a good manager and their boxer is they want to get them from prospect to title contention to title fights as fast as possible, taking as minimum amount of damage as possible because they know the next six fights at the top is where 99% of that fighter's career earnings are going to be made. And then as soon as they start the downset, they start losing and they're dropping out of the top 10, get out, you're out. It is not supposed to be a wage earning career where you just hang around for 20 years and get $100,000. That's how you get CTE and brain damage, honestly. It's supposed to be get to the top as fast as you can. And if you're not good enough to get to the top, get out. You're out. You're not good enough.
And going forward too, what is your like aspirations for this? Like the resolution, what would make you be happy with all the years that yourself and everybody involved have put into this throughout the years?
So we have to fix the sport. We have to fix the structure of the sport to return competition. And there are only two solutions to this. I know people believe there's others. There are only two. And the two are we're doing both. We have to have the Ali Act amended to include mixed martial artists and other professional combat sports athletes. And really, why that works is the promoter can no longer control rank and title. That is now independent of the promotion. That creates real free agency because now I have an independent path to the title. It doesn't matter who's promoting me. I don't have to bow down to a promoter that is seeking to undermine me or pull the carpet out from under me or refuses to allow me to advance because they don't like my style. That would go away. And then the second thing is the antitrust suit. We have to sue them in antitrust to create competition. So one of the things that we're asking for in the antitrust suit, in addition to damages, we're asking for a large amount of damages for the prior harm. We're asking for injunctive relief. And injunctive relief means we're saying to the court, enter an order prohibiting the UFC from doing the acts which allowed them to obtain the monopoly in the first place. And to a large extent, that is the long-term exclusive contracts. So if we got an order from the judge saying the UFC's contracts can be no more than 1 year, including extensions, including everything, you'd see a lot of Francis Ngannou's. In fact, John Jones wouldn't have re-signed with the UFC, I'm fairly sure. He would have waited out the year. Jones and Ngannou would have both been free agents. Um, Steven Espinoza or somebody from Showtime or um, Max or some other broadcaster would go to Ngannou and Jones and they would say, sign an option. I'll pay you each 40% of the revenues made on this event. Rotor will split 20 and pay the expenses with the remaining 20. And they would end up making $40 to $50 million each. They'd sell an event like that in Dallas Cowboy Stadium, 100,000 tickets. They'd broadcast it worldwide. It would make over 100 million in revenue. That's how boxing shows work. So when you hear Dana White claim every boxing shows are going out of business sale,
Yeah.
well, I guess boxing's been going out of business for over 120 years because it does massive, massive events 6 to 8 times a year, and they pay out multiples of the UFC. They always have.
That's that's a good because yeah, that's his go-to line at times when it comes to boxing. So
Yeah, I mean, here's another line. We cribbed it from John Nash, but I love it. So in boxing, during the past, say, 12 months, you had about 12 boxers who made 8-figure paydays for one match.
wow.
In MMA, you're going to have two, only two. But they had to be boxers to get it. They had to box. They're not doing it in MMA, they're boxing. Nate Diaz and Francis Ngannou. That doesn't tell you there's something wrong with MMA.
And on that note, Rob, this has been very informative, and I really appreciate you sharing your time here. How can our viewers here at Sportskeeda MMA stay up to date with everything that's going on with this class action lawsuit and just any updates going forward of how they can follow and support you?
Yeah, so fans follow MMAFA.tv on Twitter. And then for any fighters or industry people watching, go to UFCclassaction.com. All of the major filings are linked on that site as PDFs. So you can download the class certification order, the complaints, the expert reports. A lot of the best evidence will be right on that site. And we also have a contact box. So fighters, provide us your contact information so we have it going forward. You're going to start receiving at some point in the not too distant future communications from class counsel in the case. So we want to know where you are so we can reach you.
Highly recommend that follow. And Rob, again, I really appreciate you sharing your time and giving us some more insight on this. And I wish you all the best with this class action lawsuit.
Hey, thanks for having us on. Thanks for covering.